Hi, everyone. My name is Chloe Snider. I'm a partner in Dentons Litigation and Dispute Resolution Group in Toronto. Much of my practice is focused on corporate litigation, including transactional disputes.
Hi, I'm Alex Farcas, and I'm a partner in the corporate group in our Toronto office, and I also serve as the co-lead of our national M&A group. In our recent report, The Shifting Tides of Cross-Border M&A, Dentons, together with research provider Merger Market, surveyed 150 executives involved in cross-border and global M&A to see how these executives view the market. And what was clear from the survey results is that deal makers are doubling down on risk mitigation strategies to protect their interest. And one area that has received some recent scrutiny relates to the application of material adverse effect clauses, or MAE clauses, in purchase agreements. Now, MAEs are a common concept in most purchase agreements, and they're usually intended to provide the buyer with the ability to walk away from a deal if the target suffers a significant setback in its financial condition or its operations. In effect, an MAE would have to result in a business losing a large portion of its value for an extended period of time, and that's usually measured in years and not months. Over time, the definition of MAE has evolved to include various types of events and occurrences that will be deemed not to result in an MAE being established. For example, natural disasters or war, or more recently, the COVID-19 pandemic. Generally, MAE disputes are not very common due to the historically high bar required for a successful MAE argument to be made. However, a number of decisions over the past few years have provided some guidance as to how courts think about a buyer's ability to walk away from a deal, particularly when it comes to the interplay between the definition of MAE and interim operating covenants. Now, interim operating covenants govern a target's operations during the period from signing to closing. Historically, practitioners and courts looked at the MAE definition and the interim covenants as generally distinct provisions that don't usually have direct overlap unless a covenant is expressly qualified by reference to MAE. However, we have seen a recent shift in the case law, as my colleague Chloe will explain.
Thanks, Alex. As Alex was saying, there's fairly recent Ontario case law that addresses MAE clauses and their relationship with ordinary course covenants. Although sitting where we are now, I would say perhaps less case law than we might have expected as a result of the pandemic. And I think that's because the case law that we did see was generally seller friendly, and businesses may then have taken their cues from the existing case law that we did see. And that case law sets a high bar for buyers to establish the right to walk away from an agreement based on an MAE clause or an ordinary course covenant clause. As Alex said, while an MAE clause addresses events that occur between signing and closing that are external to the parties, interim covenants like ordinary course clauses address the manner in which the seller has to operate the business during that interim period. And importantly, unlike some American case law, Canadian courts have looked at the subject agreements as a whole to try to understand the interplay between MAE clauses and ordinary course covenant clauses, and have found that MAE clauses and the allocation of risk in those clauses can inform the interpretation of what's required by an ordinary course covenant clause. In other words, the meaning to be given to the ordinary course covenant clause and whether or not the target company breached the clause in responding, whether it's to the pandemic or all of the various supply chain issues that are now arising, or any other external aggravating factor, was informed by the allocation of risk in the MAE clause. So it's really important to think about this allocation of risk up front and in the drafting stage. And I do find that it can be very helpful when I'm involved in the drafting of M&A agreements to help clients think about what type of risks might arise after closing or in the interim period. And so one way to think about this is to provide in the agreement that the ordinary course clause must be interpreted without reference to the MAE clause, except to the extent that the ordinary course clause is specifically qualified by an MAE. I understand that this, despite the case law, hasn't really become the business standard, but these are the types of things that you can think about at the drafting stage. The last point I'll make in terms of the case law is that, the documents matter and the reasons for termination matter. And so it's really important when determining whether or not to terminate an agreement based on an ordinary course covenant or an MAE clause to understand that the way it's documented is going to be important, and to speak to counsel at the time of making that decision to ensure that the record reflects the real reasons that you've made the decision and that you want to be able to ultimately show that you were taking valid steps to terminate. To learn more about MAE clauses and generally what's motivating deal makers in the M&A space and protective measures they're using to mitigate against risk of all types, you can click below to download our report and to get contact information about our team to discuss how we can help you protect your interests.